have to continue to take legal education classes, and you don't have to take malpractice insurance. So because of that, they say to you, you are not allowed to give legal advice. So you are not my clients, I'm not giving you legal advice. It gets in the way sometimes, although it does come in handy when your cousin's kid has a DUI and wants you to go in and handle it. You can just say, I'm sorry, but I am prohibited from giving legal advice. Well, Joe did a pretty good job of covering a little bit at least about the laws that protect people against age discrimination. Principally, there is a federal law, the Age Discrimination in Employment Act, and there is a state law, the Illinois Human Rights Act. Some counties and cities also have laws. If you are employed in the city of Chicago or you are employed in Cook County, there is a city commission and a Cook County commission. And they are pretty good organizations. They are a lot more employee friendly than the federal ones are. And in point of fact, we are becoming, as the federal is becoming less and less friendly to all kinds of discrimination claims. Let's guess why. In fact, and the Age Discrimination in Employment Act was not, when you think of discrimination, when you look at race, sex, religion, national origin, that all came about in 1964, the 64 Civil Rights Act. And that law has certain rules about what you can get and how you prove things and what the standard of proof is. But age is at the federal level, age is a separate law. It did not come about until 3 years later. And the damages are considerably more limited. All of these statutes, whether it's the city, the county, the state, or the feds, it's all protecting people over the age of 40. So you can discriminate like crazy against people who are too young, but you can't, you can say you're too young. You can say, Pete, you're too young to run for office, because that's not exactly employment. But you can't say, if they're employees and not running for office, you can't say, Bernie, Joe, you're too old for the job. So you will be hearing, though, and I think as you just kind of tie this into the election, people are talking about age. And I'm well into the protected age group, and people my age too are saying, well, do you think this person is too old to run? Do you think? So, and sometimes it's okay if we say it, but if somebody younger says it, then it's not okay. Just like, if it's not your group, they can't complain about it. But so let's just take a look at the federal law. Federal and state, if you are a current employee experiencing age discrimination, like you got fired or you got passed over for promotion or whatever, you have 300 days from that action in which to actually file a charge of discrimination. Now, it is all along, through all of my years practicing, there was never a question in anybody's mind that a failure to hire someone because of age violated the law. The Supreme Court, in a very recent decision, just either last year or early this year, has let stand a lower court case that says, unless you are an active employee, you do not have standing to file under the Age Discrimination in Employment Act. And most age discrimination cases are claims of not being hired, because that's what Joe was just talking about. The state of Illinois, however, clearly does protect people who are applying for the job. So hiring cases can be brought at the state agency or at the county agencies. To the best of my knowledge, DuPage County does not have its own discrimination agency. So if you are employed in DuPage County and you are discriminated against in DuPage County, you have to rely on the state agency or on the federal agency. Additionally, damages under the Federal Age Discrimination Act aren't as good for age as they are for sex, race, and some other things. Basically, you can get back pay, you can get your legal fees paid, because of course it was lawyers who drew the act, so you gotta know you're gonna get legal fees paid. But there's no punitive damages, there's no pain and suffering damages, as you can get in some of the other types of discrimination. There is something called liquidated damages, which if the employer is found to be willfully, and that means like really egregiously violating, they can double your back pay losses. The state Illinois Human Rights Act, however, and the city and the county give to age complainants the same kinds of damages that they give for sex, race, and other things. They don't distinguish between them. Now, the major question that I saw arise as Joe was talking is, how do you prove it? And the person at the Human Rights Commission was absolutely right when they said there is no specific law that says you cannot ask a specific question. You just can't use it. Now, generally speaking, however, because I used to be an investigator and I used to supervise investigators, when you are trying to determine whether there has been discrimination, a piece of evidence against the employer is that they asked it. The very fact that they asked the information makes you believe that they needed or wanted to have the information. And in another context, for example, this often came up with women who were applying for jobs who had small children. There's nothing that says that you cannot ask in an interview, do you have small children? But if the woman then files a charge of discrimination, the investigator will say to the employer, well, if you didn't care, why did you ask? So those things can be used as an element of proof, the fact that they are asked. How do you prove an age? Let's say you come to me and you say, I think that Michaels didn't hire me because I am older. By the way, that statement that was given to you about the fast-paced job, if I were Michaels' attorneys, I would tell them, no way do you say that to anybody. Because that does sound to me like an element that indicates age discrimination. And I think that an investigator looking at that kind of admission would definitely jump on that person. And certainly as a plaintiff's attorney, if I had the person on the stand that said that, what is a fast-paced environment? What is there about this applicant that made you feel that he could not do a do this in a fast pace? The way most discrimination cases are looked at, analyzed, and proven is by what we call comparative data. So, I apply for the job at Michaels, I don't get the job at Michaels, somebody has said, I know that somebody said something about a fast-paced job, even though I know that wasn't Michaels, that was the other one, but somebody says I'm about the fast-paced job, that gets me in the door to file my charge. Now what the investigator will do is go back to the employer, send them a questionnaire to start with, and say, who was hired for this position? How old were they? What were their qualifications as compared to the qualifications of my age discrimination complainant? Is there an indication here that, and how many people are in this position? And what are the ages of the people that you have in this position? So if you start to put that together, and what you find is that the older applicant, in fact, has 20 years of experience doing X, Y, Z, and has from their, well, they probably won't see your evaluations for your own job, but if you worked at a place for 20 years, you gotta figure you were doing a decent job, right? Or they wouldn't have left you there for 20 years. So if you've been doing X, Y, Z for 20 years, and the job requirements are to do X, Y, Z, but instead they turned around and hired somebody who was 24 who had X and Y but not Z, then there's an inference that in point of fact there is age discrimination, and there is enough evidence to at least send that case to a full trial. wherein the employer now, the burden of proof shifts to the employer to articulate a non-discriminatory reason and establish a non-discriminatory reason for the actions. Why did you choose the 23-year-old and not the 60-year-old? Now, I'm not saying that this is easy, because it isn't easy. When I started doing this kind of work in 1980, it was considerably easier to prove discrimination claims than it was by the time I left the practice of employment law about 8 years ago. The laws didn't change. The judges changed. The interpretations from the agencies changed because different people were being put in to make the decisions. And I was starting to get to the point where I was saying to myself, geez, I don't think I got dumber. I don't think I got worse at choosing my clients. I don't think I have a lesser understanding of the law. Why is it that I was winning 80% of my cases when I started out on this, and now I'm down to winning 20% of them? You don't need to change the laws. You need to change who's in charge of administering the laws if you want to, knock some folks out.
Do you think that online had a lot to do with that? Because now they're asking your age online, so you never even get into the interview anymore.
They really
they used to have to ask you the age at the table at the interview, you know what I'm saying? Because they looked at your resume, they called you in, they saw you. Now
the other thing is, let's not kid ourselves. You sent in a resume that said that, you graduated from the U of I in 1969.
Well, I take those years off.
Yeah, I know, and you can, but there's still ways for them to futz it around, which is another thing that makes age discrimination hard. I mean, the other thing that makes it particularly hard is you have a position, and sometimes, they already know who they want for that position. So they structure the job requirements to match, who they want to, what they want to have in there. And then it becomes even more of a burden for the employee to be able to establish that that's a pretext, that that's not the real reason you made that up, because if you're going to be selling widgets and the job is selling widgets, the fact that you have a qualification where in the past you were, president of your fraternity 3 years ago, it doesn't relate to the job. Yes, sir.
Another way they do it in the tech industry, and I've experienced this, I'm 46, I've experienced it for a while. In the tech industry, so when you go to apply, and you get in, right, because there are older, good programmers, it's the content, and this you can really hard to prove in the court of law, the content of what they ask. In the tech industry, they don't ask a lot of times real world questions.
Yeah.
Like anything practical, like you do in your day-to-day life, your job. Instead, they say, what's the secret twisted backflip algorithm to merge 82 snaggles into a super box? And you're like, what? So they ask a very focused question that someone freshly out of school, a snaggle box?
Yeah, right.
I know snaggle boxes.
Yeah,
And
you're right.
That's what they're looking for. They're looking for snaggle boxes. And you've never heard of a snaggle box, even though you're a full-time programmer, and on the website, it doesn't say anything about snaggle boxes.
That's right. That's absolutely true. The other difficulty about bringing a charge on failure to hire is that unless you know somebody inside, you don't know who got the job.
Right.
And that's always a difficulty. Because at least going in the door at these agencies, you have to be able to give them some reason why you believe your age was a factor. You can't just go in and say, I know I'm great, they really should have hired me. So, it's now if you are an employee and you've been at your employer for 20 years. You know, and now they say, we're eliminating your job. You know, it's just a job elimination. And you walk out the door and your friend, you know, Jim calls you and says, you know how they eliminated your job? They changed the title, took off 10% of it and gave it to the 30-year-old guy down the way. That's how they did it. Now you know. So now you can go in and say, file your charge and say, bring them in and have them justify, you know, what they did. But it's really hard on hiring. But still, the fact that this recent Supreme Court decision seems to take hiring out of the picture is a concern. Enough of a concern that there is now, God knows if it'll pass because we know how the Senate is, something called the Protecting Older Workers Against Discrimination Act. It is a bill. At this point, I don't know what the status of it is, but the purpose of it is to overcome the Supreme Court's decision to make certain that hiring is a factor, you know, that a failure to hire can be brought under the federal law. Yeah, you have a question?
A couple weeks ago, I was talking to a friend of mine who's an HR talent, and he was talking about, he said, if you have government contracts, that you're required to get certain information. We were talking specifically about race, and they look at the geography of
Yes.
where you are,
Yes.
and if it's 50% black and 25% Hispanic, you better be hiring those percentages to be able to show that here's why you didn't. Would the same rules apply to age?
Yeah, they can. What you're talking about is an EEO-1 report, and these are for people who do business with the federal government. And there has to be, and so they report back on, you know, how many of this race, how many gender, in these age, in these different job classifications.
That's why they have to ask those questions too.
Yeah, okay, and the Illinois Human Rights Act, if you do business with the state of Illinois, there's a section of the Illinois Human Rights Department that is what they call the Compliance Department, which is where I started before, when I worked there. And what we would do is we would review those, and if there were discrepancies, we would do on-site investigations. We would go in, we would interview people. It was a fun job, because like I did Andy Frayne, and I got to go to the ballpark, and to this day, I go to the ballpark, I count how many women, how many black people, how many older people. You know, it's like it's in my DNA now, every time I look around, you know. But, okay, so yes, there are EEO-1 reports, and if you file a charge federally or by the state, the investigator will ask for the EEO-1 to see are there discrepancies, and that's just another piece of evidence that they look at to try to decide, in point of fact, has there been discrimination? Now, it's lovely that they put out those reports, but what did I just say? They're only good if somebody looks at them. And somebody cares about them when they look at them.
If somebody files and is
And
called
somebody
on it to produce.
follows up on them. You can have federal compliance, just like the state. You can have a division of EEOC that goes and reviews federal contracts. But they've got to be funded. They've got to have people there who will do that job. They've got to be, and this is one of the problems that we have that has developed. And again, it's not as bad. The difference between filing something, when I was doing this, if I could get into the city, if I had somebody who employed the city of Chicago and I could get into the city of Chicago Commission, that's where I wanted to be. Because there were much more sympathetic people there than there were other places. Somebody needs to yell at me when my time is up, by the way.
Your time's up.
Okay.
He's a timekeeper.
Is that a?
It was 20 minutes, perfect.
Okay, so is there any one or two additional questions, or are we good with this? Yeah, one more.
So, if you were saying, sorry, earlier we were talking about insurance being an issue, like people were.
Insurance?
Yeah, so because insurance is more expensive for older people, and it's one of the reasons employers are less.
Well, that's health insurance issues.
Yeah.
That they,
So from a policy side, is single payer healthcare
Yes.
Oh, hey, look, guys, I'm a Democratic PC in Elmhurst. I mean, I'm on the same team. Yeah, healthcare is, when I handled discrimination claims in the beginning, again, in the somewhat good old days, if I was negotiating people out, and most of these things settle, right? I mean, most of them settle, most of them go track. You know, we would settle for like a chunk of money and whatever. By the time I was done, we were negotiating people's severance package for healthcare. That was it, man. Because if you did, because it was so expensive, and people were desperate for healthcare, and that was what we were negotiating. I mean, forget punitive damages or emotional distress damages. Just get this person insurance until they can get to the next employer. And tying healthcare to employment.
And exactly when did companies start doing that? I can answer it for you if you'd like.
Okay.
Right after World War II.
It was during World
During World War II,
Yeah.
right?
Yeah.
And
Oh, yeah.
you tie, it's the way to tie your people to a company, make them your slaves. They're your slaves, guys. If you haven't, we're all slaves here. I hope we realize that.
But it was, they had a shortage of people available to work because so many people were in the military.
Yeah.
And so it was an incentive to draw
Sure.
people.
It's
So, but then
absolutely.
everybody got used to it and so.
absolutely.
Right.
What started as a benefit has become a